কোথায় গেছি তাই sudah ketemu sih kalau habis itu kamu ketemu 대출을 우리도 몰라. 근데 될 알을 보고 무슨 모두 가이드가 하프를 그냥 알지 뭔 나가리 알지는 뭐 자세히 기능이나 이거 hello, Brian. Isn't this Mr. Borgohan's number? Oh, oh yeah, yeah, his relationship is asking, that's right. Huh? Another 10 minutes? Another 10 minutes. Please, kalau timeline begini itu timeline. Harus jangan sampai. Dan tak sampai. Jadi, namanya bagi kita harus berapa yang itu. Ini sampai ini delivery benar. Dia apa? Itu lo bawa kita jadi mesti itu. Now, betul ya. Pada itu. 2 o'clock position na.
Gauhati High Court. Boss. High Court needs to review Gauhati.
Actually, at 2, I have another engagement. That's why I just at 12, it was our this reference
Yes.
farewell was there. That's why
I am
was
so
just
sorry.
mentioning.
Right after mentioning here,
Ah.
I have to rush back to where I am staying. I had a matter in court number in Honorable Justice Burwa's court. Devasis Burwa.
Oh, through VC you have
Through
taken
VCA.
that. Oh, acha.
That was why I was running from here to there. Anyway, the Kohima weather is pleasant.
Yes, yes. We are
That's
enjoying.
that I am also enjoying.
Last 10, 12 days, I am enjoying.
Yes.
Unlisted motion, item number 18.
My lord,
Yes, I have just gone through your record when
Yes,
I was
yes.
called for the record. The fact actually regarding his compulsory retirement is known to us because this is the full court decision was there and he got compulsory retirement.
my lord.
So about that, you no need to.
No, I'm not going to plead on that, but I want to give what my lord will appreciate one thing. Be it the bar or the bench, we are the judiciary. We are a family.
It's
We are a family. When someone casts us, any outsider casts us apprehension, it is not on that particular individual officer or individual advocate. It is on the judiciary itself. So one cannot look it in a very cavalier manner. That is one aspect. Now, my lord, yesterday, while I was coming to Kohima, my colleagues at the bar were informed that other two accused approached the honorable court. So now we see that live streaming is really beneficial. So when I was at the proceeding yesterday at night, so my lord has put two queries. One was with respect to the treasury, and second was that your lordship has taken a view, prima facie, that registry officials have gone down there. So in that context, I would like to place one judgment of Honorable Justice Ujjwal Bhuiyan. Kindly peruse Jamuna Gogoi Fukan. That's a very why I want to put it.
yes.
Yes.
Para, you're insisting any.
My lord, Jamuna Gogoi Fukan. Para 4. It was with respect to a service matter only, my lord. Before we proceed further, it would be apposite to remind ourselves about the duties of a judge on the administrative side as well as on the judicial side. A high court judge not only discharges judicial functions, but also discharges administrative function. A decision taken on the administrative side is certainly open to be scrutinized on the judicial side by invoking the power of judicial review. The duties of a judge on the administrative side, vis-a-vis on the judicial side, was secondly delineated by the Honorable Supreme Court in the case of Madan Mohan Chaudhary versus State of Bihar. And we feel that it would be most appropriate to extract the relevant portion of the same, which is as under. I'm not reading that, my lord. Kindly come to para 5. In the aforesaid judgment of Madan Mohan Chaudhary, Supreme Court has aptly remarked that though on the administrative side, High Court judges might have acted as bureaucrats, once they don the robes, they forget all their previous associations and connections. the transformation is so complete and real that even though they themselves were part of the decision-making process, they quashed their own administrative decision in exercise of the power of judicial review and thus maintain the majesty and independence of the Indian judiciary. I'm just putting it. Now, when this matter came to me, I was also shocked. Why? Before I go into the merits, my lord, your lordship was, before donning the bench, your lordship was in the sessions court. Now, in my 17 years of practice, we know only one thing, that under 437, 438, 439, bails have been passed. Now, bail order has been passed by the Sessions Court or the CGM court, exercising the power under 437, 438, 439. Now, in that order, the Sessions Court or the competent court passes a direction that on such and such amount, surety, two sureties of like nature or the amount is been paid, then he will be released on bail, because that comes under 441, bail and bail bonds. Now, what we do? Your Honor has passed the order. My Lord has passed the order as a session judge. The order has been passed. Now, it is the duty of the counsel and the accused persons. They will bring the money. In Assam, we hardly find cash. It is always in the FD. We come and give it to the court bench assistants, payskers and all. They do the needful. It comes to the sessions court. If my lord is exercising the power under 439 with respect to a case trial by sessions court, normally it is CGM. They will verify the surety, and accordingly the person is released. And what we do with that FD, my lord, the court officials, they will deposit in the district treasury under the respective head, right? Now, that is what the normal process is. That is what the Gauhati High Court criminal rules also speaks. Now, in the state of Nagaland, when the matter came up, I inquired. In the state of Nagaland, forget about this case. Forget about this case, my lord. Rampant practice, what is following is that you bring cash, they give a receipt. Court gives a receipt, and that cash has been deposited in the account of some judges or in the account of the court. So that the amount is not deposited in the state treasury, which is totally illegal. Because as per the criminal rules and forms, my lord will appreciate that there is a proper mechanism is there, because that has to be audited. Because that amount has to come back to the court when the case gets discharged. Now, what happened in Nagaland, when I was posted as CGM, Kohima, my predecessors, they took cash deposits. And the predecessors went. So the cases who got discharged, who got acquitted, conviction, they used to come and ask money, but I don't have that money. So the people perception was that me, as the CGM, at that point of time, might have taken away the money, siphon of the money. So that was a very serious issue. So what I did was that, my lord, I wrote a letter to deed and protocol judge. My lord, that's a very confidential document which I have secured, and I have specifically mentioned in my petition that I will be placing it on a seal cover. My lord, may kindly see. It is of 2/9/2013. My lord, may kindly see the confidential paper. The paper.
Yes, I have.
I'm not rereading this one because it is a confidential document and it is a property of the record. I have raised this issue to the then protocol judge, that what is exactly happening in Nagaland. The amounts, my lord, will kindly see Annexure A.
Annexure
Annexure
A
A.
of your confidential or?
Yes, my lord, confidential, that document which I have given to you, my lord.
Yes.
These are the communications, respective communications, money receipts, orders passed by the lead and court, which I have brought to the knowledge. My lord, I keep it here, this one. That this issue of cash deposit and no treasury head, that has already been raised by me in the year 2013. Now, the second thing, very interesting, is that as my lords have already in the opening statement, my lord has taken the view that with respect to my compulsory retirement, that is no longer a res integra, it is already in the records. I was shocked when there was an order passed which I have been annexed in this in my petition, annexure P1, P1 of the copy of the Honorable High Court.
Page?
Page 22.
Yes.
Yes. That order categorically states that since I was appointed by under Nagaland Judicial Service Rule 2006, proceeding was drawn against me under the Nagaland Judicial Nagaland Public Servants Discipline Appeal Rule 1967. When that inquiry was pending, you exercised the power under under Rule 2006, voluntary retirement, which you gave in voluntary and compulsory retirement. So it is a settled law that compulsory retirement is not a stigma, because your honor my lord can do it under 50, 52, 55. But when that entire exercise was challenged in the Honorable High Court, it is still pending. Most probably it is coming up on Wednesday, that matter. But this matter, what happened was that a departmental inquiry was issued to me on a proceeding, which I have challenged that the service rule does not have the power. The Nagaland the Disciplinary Appeal Service Rule does not have the power, nor in the 2006. So under what authority you are doing it? The government of Nagaland took the stand, the Gauhati High Court Standing Council took the stand that since Nagaland does not have their own pension rule, they follow the pension rule of Central Civil Services Pension Rule 2021. And according to Rule 9, a continuity of proceeding, so this can be done. So the Honorable High Court took that, yes, that is, so that order was passed. And against that order, I have specifically mentioned that I am going for a special leave petition. I played in my interim pair also, that is there. Now, why I report these two aspects was that I was officiating the office of Principal District and Session Judge Dimapur. Madam, kindly note the timing. From 1st October 2021 to 2nd October 2024. My lord. Your lordship is there? Yes. Now, on 3rd October 2024, I was transferred to District Mon. That order is there, my lord. Your lordship will kindly find page 35. Page 35. Yes. Page 35. I don't have pagination. My lord has the pagination paper. Yes.
Yes.
Slot number 4. Number AC High Court notification. My lord is there. Inalu Jimombi, Principal District and Session Judge Dimapur is transferred and posted as the District and Session Judge Mon by Srimati So and So transferred. He will hand over the charge of his court and office to CGM Dimapur and proceed to join his new assignment immediately. My lord. So on 3rd October, that order was passed. On 7th October, that your lordship will find page number 37. 35.
35 is a notification.
No, no, 30, I don't know my numbers. It is 37. Second last page.
Yes,
Yo.
37.
Yes. So. In hurry,
He
Lordship.
He
Yeah.
gave charge in fact.
Yes. Your Lordship will kindly see. This was also very much surprising to me. Kindly see the heading of the form. Assam Schedule 3, Section 1, Form number 81, my lord. Certificate of transfer of charge. Now, my lord,
So this is actually this Nagaland judiciary or Nagaland they don't have this kind of the transfer charge.
no, your
That's
lordship.
why the Assam Schedule 3 is.
Yes, Schedule 3 is formed. And why the Schedule 3 is what? That's under Rule 145 of the Assam Financial Rules. I will come to that aspect. Now, your lord.
It's okay. Now question is that he got transfer order on, he was a district judge on from 1/10/2021 to 2/10/2024.
My lord.
And on third,
The order came on 3rd. On 7th, I handed over.
Joint.
No, handed over. Now, this thing is that since Nagaland does not have their own financial rule, they follow Assam financial rule.
Yes.
Now, Assam financial rule, your lordship will appreciate this fact. When my lord was officiating at the office of the district and session judge at that point, because it's very convenient for us. Okay. So your lordship, a transfer order wasn't passed. My lord has gone and taken charge as a relieving officer or has relieved also. So what we do normally is that when you hand over a charge, you give the indentures, you give the accounts, it has to be there because no officer is going to take up otherwise accounts. And if there is any discrepancies, it is in flagged by both the officers concurrent because that order has to be immediately sent to Comptroller Auditor General of the AG branch. AG branch.
Yes.
Now, my question is that when I handed over my charge on 7/10/2024, that is, 7/10/2024, nothing was flagged. It was engrossed that there is an amount of 1,69,13,000. Now, my lord will kindly see, this is the general transfer of charge head which Assam follows. And this is the relevant rule. One copy. This is the relevant rule. Kindly come to Rule 145, transfer of office. Every transfer of charge of a gazetted government servant should be reported by post on the same day to the comptroller. For transfers of charge, the following points should be observed. The cash book or impressed account should be closed on the date of transfer and a most recorded it over the signature of both the relieved and relieving officers, showing the cash and impressed balances and the number of unused checks, if any, made over and received in transfer by them respectively. The relieving officer, in reporting that the transfer has been completed, should bring to notice anything irregular or objectionable in the conduct of business that may have come officially to his notice. He should examine the accounts, count the cash, inspect the stores, count and weigh the certain selected articles in order to treat the accuracy of the return. He should also describe the state of the records. In the case of any sudden casualty occurring or any emergent necessity arising for an office to quit his charge, the next senior officer of the department present will take charge. That is with us. When the person who take a charge is not a, he must at once. So my lord, what I am reading is that, which is more important, is that Rule 144(2). My lord has, when your lordship was as a district judge or in the judicial service, we have followed that one. We cannot bruise aside because that has to be reported. Now, on the day of 7/10/2024, the record speaks that everything was fine. Right, my lord? Now, when my service matters were pending, compulsory retirement, my inquiry was pending. On the day that judgment order was passed, at evening I came to know that an FIR has been registered in it. Now, my lord will appreciate one thing. It's very unfortunate also. The judiciary comprised of the Supreme Court, the High Courts, and the subordinate judiciary. We cannot call lower judiciary. It has been castigated in a lot of things now. So it's very unfortunate in one aspect that when an allegation which is recently has come up in some courts, very unfortunate. We don't know what is going on, what is there. But as far as the records reporting is seen, that gentleman, sitting judge, was being transferred to other high court. Whether the impeachment will be done or not, that's a different thing. The Honorable Supreme Court, in K. Venkateswamy Swamy's case, has held that the judiciary, as far as the judges and all are concerned, high court judges and the Supreme Court judges are concerned, you cannot register an FIR. You can't register an FIR. There is an in-house procedure is there. And the in-house procedure, on the basis of that, the Chief Justice of the High Court or the CJI will take a call. That is the law now. Now, why does we go? The district judiciary. The officers of district judiciary. My lord, the Gauhati High Court, the Gauhati High Court Registry Vigilance has issued notice, 2 notifications, of course, which I have annexed it. Annexed it. Page 32, if I'm not wrong, in my 2017 notification. Annexure P3.
Yes.
This notification, my lordship will be well aware how the complaints again the subordinate judiciary has to be entertained. Now, it says that it has to be sworn by an affidavit and it should be duly ascertained the facts. The committee, normally the administrative committee of the court, they will look in, after that take a call. Now, in the present case, I will come to that FIR part. What happened is that these are the factual things, my lord, which I am dealing with it at this point. So I came to know on 26 that FIR has been lost in use. So what I did as a normal procedure, I applied for certified copy. Kindly come to the annexure P4. My lord is there?
Yes.
Yes. Copy of the FIR, copy of case bail register, letter from High Court. Letter from High Court. Now, only the FIR was being given to me. These 2 documents were not provided. To the best wisdom of the learned CGM, Honorable CGM. I'm not casting any apprehension, but it has not been provided.
Yes.
The moment it not been provided, because if your lordship will kindly come, keeping this thing in a flag mark, kindly come to the FIR. That is 26, annexure P2. P2. Kindly come to the written FIR, a written FIR by the district and session judge.
Yes. 28.
Yes, my lord. To the officer in charge, West Police Station, Dimapur, Nagaland. Subject FIR. Sir, as directed by the Honorable High Court, I undersign. My lord, I pause it for a moment here. The basis of the FIR was as directed by the Honorable High Court. Now, Honorable High Court is what? Who constitute the High Court? Is the registry? No. It is the entire administrative setup of the Chief Justice, JAD, and the administrative committee, and the assisting officer, that is the Registrar General, and the registry staff. That is the High Court rule says, Your Lordship, Chapter 1. So the moment it has been directed by the Honorable High Court, the letter, I must have the copy of the letter. Because I have to challenge it. Because if the High Court has directed an inquiry that you lodge an FIR, if the High Court has directed an inquiry, because I'm a judicial service servant, still because of that order of passed by Annexure P1, I'm still in service for the deemed inquiry. Legal fiction is there. Because till Supreme Court set aside that order, I'm still a government servant, a judicial servant. So if you want to proceed against me, then there has to be an order passed by the Honorable High Court in the administrative capacity presided by the Honorable Chief Justice, JAD. So here the letter says as directed by the Honorable High Court. So I wanted that letter. So in the absence of that letter, I am handicapped now. My Lord, you will appreciate this aspect. Now, the complainant say, I would like to inform your esteemed auditor, sum of 14,35,000 was detected to be missing in respect of cash bail deposited by the accused bailer in connection with pending criminal cases before the undersigned court. So he came to, he was detected. Upon verification of the record by the undersigned, the missing cash bill pertaining to 29 GR cases, which was found entered in the case bill register in the year 2024. Upon verification of the case bail register, it is observed that the entry was inserted between the gap, it should be GAP of other entries showing deposit of the cash bail amount without making actual deposits. Okay. The following are the officers and staff who are responsible in handling the said cash bill and records during the relevant period. Principal District and Session Judge, that is me. Okay. Staff in charge of cash bail register, who? That is one co-accused. Staff who allegedly received the cash from the bailers and accused. So these are the two persons, one who received, one who maintained the register. Now, I'm very fortunate today that my Lord comes from that judiciary hierarchical system. Your Lordship will appreciate. When a cash bail has been paid at very instance, it has been done by the staffs. My Lord does not take the FD. Because that report will be filed by them, the court. That is a normal procedure. Your Lordship will see that if it is CGM on, the CGM will verify it. And if it comes to your Lordship, that's 302. Because CGM cannot pass. Then my Lord will look into it. Yes, okay, call the surety. So I just make an endorsement at best. So neither me who collected it, nor I said that can't be done. And the FIR speaks that fact. And my Lord, there is a saying. We should not do our dirty laundry in public. There is a saying. I understand that the corruption should be nipped at the bud. But there is certain amount of procedural conventions which cannot be bypassed. You cannot act in haste. I am not an individual or government servant. I am a judicial officer. I am a sovereign entity at that point of time. That is what All India Judges Cases Supreme Court, Honorable Supreme Court has said by Deed and Chief Justice Chandrachud. He said regarding that pension benefits and all, you cannot equate the judiciary, the judges with IAS and IPS officers. The judges are a sovereign entities under the constitution. At best, it used to be the ministers of the cabinet. You cannot take them an IPS officer or DG or anything. I am that. I am ready to cooperate with the investigation.
It's okay.
Well,
You just complete it.
yeah, I'm ready to cooperate with the investigation. I won't play the judgment of All India Judges case. That is also is there. Now, after until Balaji's judgment of the Supreme Court, until Balaji's judgment of this Honorable Supreme Court, the Supreme Court directed that there has to be a model form how you are going to arrest, when you are going to arrest. Direction was issued to all the high courts, all the government, state governments. Accordingly, the state government of Assam political aid department, they issued the notification on 17 February 2025. Which was been uploaded in the Honorable Gauhati High Court's website on 3rd of I have categorically mentioned on 3rd March 2025, High Court notification in our website. This was been. So in this, according to this notification, my lord, the police officer offenses below 7 years, or if it is 10 years also, you have to go for a summon under 41A. Now it is section 35. Till now, I have not been summoned under 35. And there is no notification of the government of Nagaland. So, my lord will appreciate this, that at any point of time, I can be arrested. At any point of time, I can be arrested. That's why I have pleaded here that there is no notification, because I am also a judicial officer. I know the implications. Now, keeping this thing in view, if we go back to the FIR, very interesting, the FIR form. Huh? Yes. My lord will kindly see the FIR form. My lord is there. This is registered under section 154 CRPC stroke 173 BNSS, right? So basically this 154 form is redundant. Here what I would like to show, kindly come to entry number 3. Occurrence of offense, date unknown. Date from, date to, because there has to be a precise timing, time period, absent. Now, if the complainant, district and session judge is saying that 29 of GR cases were involved where this amount was missing, the complainant should have said that from the month of March, so and so, to this period of so and so, this is. You cannot make an omnibus allegation. So the occurrence of offense is null. Now, serial number 7, suspected person Inalo. My name is there as Inalo. Okay. Now, this is one FIR, my lord. Okay, form. Kindly come to. Yes. Kindly come to the 173 BNSS form. That is page 30, which is the present FIR form. Serial number 3, same. Serial number 3, same. Come to serial number 7. Details of known, suspected, unknown, accused with full particulars. My lord. Next page, serial number 171, that is unknown. No, why I'm trying to demonstrate is that FIR cannot be the encyclopedia of evidence, anything. But what I'm trying to demonstrate is that how cavalier you can be, the police, state police. So if the format in the FIR is such way, so my apprehension that there is no standing order like in the state of Assam, in the case of Nagaland, my fundamental rights can be curtailed at any point of time. That is why I'm trying to demonstrate that. I am not going to, my lord, let me be very clear. Though I have made a specific that I want to put that the offenses alleged against me, I want to argue on that point. But Since I am praying for just for interim at this concern, I'm not going to argue at that point. I'm keeping it subsequently. But be that so, my lord, your lordship, I have pleaded in my petition also Gurbakh Singh Sibba's until judgment. But today morning, 2025 SCC, 2025 SCC. Yes, this one. I was really, what to say, I try to pat myself that my interim para which I have written, that exactly has been upheld by in this judgment which I am referring. My lord, kindly come to para 57. My lord, that was with respect to anticipatory bail. It was a constitutional bench judgment. That the issue was that what will be the duration of anticipatory bail? Can it be indefinite and all? And the Honorable Supreme Court went into the judgment from Gurbakh Singh Sibba with the principle of that Gurcharan, that bail is a rule, jail is an exception. Now, your lordship will kindly see, because there were many judgments that 438 is a fundamental right, Article 21, it comes into play. Kindly come to para 57. The interpretation of section 438 that it does not encapsulate Article 21 is erroneous. This court is of opinion that the issue is not whether 438 is an intrinsic element of Article 21. It is rather whether that provision is part of fair procedure. As to that, there can be no doubt that the provision for anticipatory bail is pro-liberty and enables one anticipating arrest a facility of approaching the court for a direction that he or she not be arrested. It was specifically enacted as a measure of protection against arbitrary arrest and humiliation by the police, which Parliament itself recognized as a widespread malice on the part of the police. Now, my lord, law is equal. Law is equal for everyone. No one is above the law. Not even the judiciary, not even the executive, not even the legislature. But if we read this particular judgment in para 57, that intrinsic part, my standing, because your lordship has to consider where do I stand, the petitionary, where do I stand? I am a judicial officer. I was or I am with a judicial officer. I have roots in the society. I have factually narrated entire thing. What I want is that, your lordship, kindly come to my interim pair. It's page 19. Under the facts and circumstances pleaded above, this honorable court will duly appreciate the fact that the petitioner is ready to cooperate with the investigation and hence prays to the honorable court to grant the interim protection from arrest, and in doing so, the honorable court may put any or all of the restrictions as stipulated under section 482(2) of BNSS 2023. If the said pair is not granted, then what will happen? It will have a cascading effect on my family. Further, I will be unable to contest my service matters which are pending before the honorable court, and further it will restrict him for securing effective legal service in filing the SLP against the order. But given my genuine grounds, because this case, even if my service matters, I succeed because recently a judgment of the High Court has also come that 6 months is the outer limit. If I succeed, but if I am arrested, again I will be back to square one. So I need to that, and I want to take part. So what I am praying, my lord, and this prayer which I am repeating, your lordship will find in the same judgment which I have referred, the constituent, where the Supreme Court has said The controlling expressions, para 66, the controlling expression under 438(2), that is at that point of time, spell out three distinct conditions which the court granting anticipatory bail can include as direction. These are that the applicant makes himself available for interrogation by police officer as and when required, that such application should not directly or indirectly make an inducement, threat, or promise to any person. So that is what I've said. The constitutional bench also says that you do it. And the directions are there in the Supreme Court that I'll cooperate. So, my lord, what I am praising at this point, yesterday I was fortunate, as I have told, my learned colleague, he said that if he cooperates, we have got done. Your lordship asked, are you saying? And your lordship also denied the interim protections as far as the two accused persons, because there was the FIR was not annexed, which your lordship has recorded. But here I have given my entire scrutiny of events. So, my lord, to be very honest, and that can be recorded, I have already moved out for my SLP matter, because I have to look after that matter. So what I am praying is that if my lords grants me the interim protection till the case there he comes, at first, let me appear before the IO and give my statement. Let it follow up, because ultimately this, whether it is siphoned off or not, whether it has been telling, it has to be done with the bank, the corresponding entries and everything. So it's a document. There is no question of tampering with those documents, or because it will be in the custody of the court, it is custody of the registry or the police. So there is no question. I am ready to cooperate. So what I am seeking is that let me approach the Honorable Supreme Court in that matter, because that is also there. So kindly protect me with any condition which I have already specifically said that I am going to cooperate. But if your lordship allows me to take part, then my lord may kindly be specific that on such and such date, I go and appear. But even this week itself, my lord, because it will be otherwise difficult. Because vacation bench has already commented in the Supreme Court that this is the issue.
Yes.
My lord, my submission is, my lord, prima facie case is that there is a serious allegation that there is a misappropriation of foreign like something. So, my lord, and the case has been registered under 316 and 337 PNS, my lord. And my lord, so my submission is sufficient time may be given to the investigation agency to investigate the matter as per the law. So at this stage, my lord, interim should not be granted, my lord.
Your lordship, yes, at least my friend is making some submission against me, not like yesterday. Be that. Grant of anticipatory bail interim protection does not take the right away of the police for investigation, because that has been held by the Supreme Court in this. Because I am going to take part in the investigation. That my learned friend must understand. I am ready to take part in the investigation. It is not going to hamper the investigation.
That is my submission, my lord.
Okay, I'll pass your order.
Your lordship will pass the order.
Yeah.
My lord,
And
just
the
one more
order
request, my lord. If your lordship, since my petition have categorically stated in the certified copy, I have not been recorded those two documents. If my lord may pass that the direct, that I will may apply again and I can get the copy. My lord.
Yeah, I have it. You're staying back today or going?
No, it depends upon the order. But I want to. My lord will be leaving tomorrow.
Yeah.
Kohima weather is such.
Yes, yes,
Really?
weather is undoubtedly. Okay.
Obliged, my lord. Much obliged.